Attorney Prashanti. This is about an H1B amendment once again. Is an H1B amendment necessary when the job position at H1B differs from the one employer is considering for EB3 employment based category 3 green card? There will be a slight change in my job duties, but the wages may vary. I'm asking this question because at some point in the PERM and I-140 stage, USCIS may question past jobs and duties. So I'm concerned about whether or not it is an issue with two different positions as compared to the H1B and my PERM.
So yeah, the main issue here that he's concerned about is that, for example, it looks like his H1 is, just as an example, filed as a software engineer, and maybe his PERM is filed as a program analyst. In this instance, there is a difference in the job title between the PERM and the H1B. While it is not ideal to have that difference, that doesn't automatically result in a denial of the PERM or a denial of the H1. The PERM is an offer of future employment. So you have to have an explanation as to why the employment in the future you propose to hire the person in this particular job while he's presently working in a different job. Maybe you foresee that you will have different requirements or a different need in the future. As of now, your need is that of, you know, is based on which the H1 has been filed. So while it's not ideal, it's better to have both same job title. Sometimes it becomes necessary to do it this way as two different job titles. Um, Sometimes because of the whole EB2, EB3 issues that come in, and because of the way H1s are approved and the way PERMs are done, there is a conflict sometimes between the job titles, etc. But in general, no matter what that conflict is, you're supposed to put the job title of the employer where the actual job title where, that the employer tells you to, and not just put some job title to get, you know, a better result for your PERM or a better result for your H1. And the job title also is not the determining factor, it's actually the job description. So that's something to keep in mind as well.
So can they still use, because, if we mix up this question here, try to look at it in a different angle, can they still use the experience from the same employer for the PERM? The same petitioning employer for both H1 and the PERM as well.
Right. Then you might have even more of a problem, because when you're doing the PERM, you're saying that the job, you have to show in order to use the same experience from the same employer that 50% of the job is different. That the job is completely different, at least more than 50% of it is different. And you have to create a table, etc., etc. So you're actually making it more difficult for yourself, because by yourself you're contrasting because of the need that you have, the difference with the present job and the difference in the job that you will be hired for. So that could create some complications moving ahead. But yeah, it has to be done. It can be done.
Well, looks like, whoever asked this question, once you watch this video, this definitely looks a little, not little, too complex for me. So I think you should definitely reach out to Prashanti if you need help with this. I don't think, it's time to play. If the truth is, this is the truth. Definitely it's taking 10, 20, 30 years, specifically, people who are born in India. And I think you should not take a chance and get a denial and waste more time. You have to grandfather the priority dates. Thanks for answering that question.